Hi. Today we're going to talk about the investigatory process and mainly focus on observing and handling evidence. So the collecting and handling of digital evidence follows a staged process. First, we'll talk a little bit about sort of a precursor to digital evidence handling, and that is forensic readiness. I spoke about this in another lecture, but we'll recover some of that material as a run-up to our discussion today. When an incident occurs, of course, we'll start with the initial seizure of components, sort of like a virtual crime tape around the scene. Then we must, of course, validate the evidence. Once that evidence is validated, and we'll discuss about some techniques to do that validation, we will need to study and analyze that material. And then finally we'll wrap up with preparing a final report. And if this incident happens to rise to the level of either a crime in the legal system or perhaps a corporate tribunal, there will be some need for testimony. So we will begin by considering the idea that collecting digital evidence isn't just about cybercrime. Data can be used to prove that an individual was treated properly, for instance. It could be used to show compliance with a regulation. Digital data, as you are aware, is the heartbeat of almost any modern organization. So, that said, there are many reasons to institute practices, programs, plans concerning the data kept, the data created, processed, and used throughout an organization. So in that business context, there is just a tremendous opportunity to take a proactive approach to all of this evidentiary data. Who wants to scramble around in a panicky manner, per se, trying to find that one piece of information to finish filling out forms for a patent application, for instance, at the last moment? So it's always important to consider the importance of all of our business records and to be prepared when that information is needed. And that information could include many things: log files, emails, backup storage, records in the cloud, even in the case of a criminal investigation, we may be looking at accounting data, call records, network traffic analysis. So, in summary, a well-written plan or program is going to position an organization to respond quickly and effectively to any type of incident, whether that incident be an act of espionage or the incident is merely, filing for a patent or, proving the ownership of some kind of intellectual property. And as a takeaway, you should remember that forensic readiness, well, as the name implies, it is a proactive approach to business records management. And although it is part of the security process, it is outside of the technology realm per se. It is more on the administrative side of the house, where it is more procedural and about methodologies. So when you are considering a forensic readiness program, there are a lot of key activities, and we did speak about some of them, and it'll be important as you create a forensic readiness plan. But you want to specify clearly in writing the collection requirements. What data needs to be collected? Where is that data? Where should it be? If it is moved from one place to another, what types of care need to be taken for that transfer? We need to define various examples or business scenarios where data may be required. So these would be scenarios like we have been attacked by a hacker, and there is an alert that's been raised by our security incident and event management system. What do we do next? Where will we find this evidence to substantiate our claim and to help build a timeline of the event so that we can work hand in hand with law enforcement to find this attacker, and also so that we can put in place increased protections to prevent future attacks. That would be one business scenario. And in the non-criminal avenue, we might be looking at the filing for a biomedical patent. So we would have many forms and probably interviews to complete, where we have to have at the ready many other forms that would prove that we own the intellectual property, we've completed all the due diligence, that all the creative work for invention is ours, and we can, prove in a stepwise manner that we are, worthy of being awarded this patent. That would be another business scenario. Not only do we have requirements for the collection of information, but we need to establish a capability for completing this gathering. So, do we have the proper storage facilities? Do we have personnel that are trained in these activities? This is something that we also have to really think through deeply when developing our forensic readiness program. Some things can be handled at like a department level or a division level, but there should also be thought put into the need to escalate the incident beyond this local level and perhaps involve law enforcement, local law enforcement, or even State Bureau of Investigation, or perhaps even federal entities. Of course, our staff needs training, not only in doing their job day to day, but also roles that would be played during an incident. Who is responsible for what and at what stage in the ongoing process. So in this unfolding of a technology crimes investigation, you can see that we have 4 main stages. We mentioned these at the very beginning of this discussion. We're going to have the seizure or acquisition of our initial data, followed by the need to replicate and validate this data. After we have created digital replicas and validated that that replica is indeed the of the identical nature to the original, we will need to study and analyze and document what we have discovered, and then finally delivering that final report, which may also involve testimony by witnesses and expert witnesses before either the tribunal or in a court of law. So let's start at the beginning. Evidence seizure. Once an alert is raised by our monitoring system that an incident has occurred, and again, this could be a breach type incident, but it also could be just some other employee initiated incident, an accusation of mistreatment. There are many ways that this alert can be raised. In any event, the response to said alert must be swift, but also must be taken with great care. So it is of key importance for our internal investigators, our law enforcement, any personnel in a lab type situation who are analyzing the data that we collect, that they understand the process and especially take great care in what's called the chain of custody. So the evidence handling is just as important as collecting the evidence in the first place. There are some key qualities to evidence, and specifically to digital evidence. For one thing, the evidence is latent. Okay, latent means not fully formed, not obvious in front of our eyes, so hidden or concealed. So this could apply to data that would be in server log files, packet analysis across the network. things that we just do not see every day, but can still be of utmost importance to an investigation. Secondly, digital evidence is disparate. It is everywhere, across the network, possibly even across the continent or across the world as data travels to many servers from origination to destination. Thirdly, digital evidence is very fragile. It can be easily tainted, altered, or destroyed entirely. And this is one of the really important reasons that we must act swiftly when collecting evidence. Which leads us to the fourth quality of time sensitivity. Both malevolent actors and an operating system itself could update the state of the machine and alter the data. So we need to collect it swiftly. Digital evidence can be found in many places, but we could break this down into three major categories. In the cloud or anywhere across the network, on a desktop server or anything that we might consider to be an end device connected to the network, or in that same category we can include standalone storage media like an SD card or a USB thumb drive. And the third major category would be on a mobile device like a smartphone or a smart camera of some type. In any event, with any incident that might occur, there is going to be a very long and probably very rich electronic trail left behind. The key is knowing how to find it and how to use it. So those three categories that I just mentioned, the network, end devices or standalone media, and mobile devices, each have some example entities, and you can see that in this chart. So in the case of the internet, a lot of the interesting examples would be that packet captures, firewall logs, email archives that would be possibly on MTA servers across the network. End devices or media would have files of all different types of extensions relating to images, documents, spreadsheets, perhaps audio files, and even databases. And then similarly on our mobile devices, there are icons that could include hidden data, app data that is stored on the device, phone calling history, photos, and even files that can be either purposely hidden or hidden by an application. Paul Kirk, who works in the forensic realm, has a sentiment here, and it's quite poetic, I feel. It says, "Wherever he steps, whatever he touches, whatever he leaves, even unconsciously, will serve as a silent witness against him." almost sounds like a sentence from a crime novel. But it encapsulates in many ways a principle that was developed close to 100 years ago by a pioneer in evidence collection, Edmond Locard. And Locard studied medicine and law in France and joined forces, so to speak, with a renowned criminologist of the day, Alexandre Lacassagne, and in 1910, Locard, I guess, pulled some strings, did some convincing, and persuaded the Lyon, France Police Department to give him some space and a few assistants, and he started one of the very first police crime laboratories. He used photography and other scientific techniques to collect and study evidence, artifacts left at a crime scene, and he is famous for the principle, every contact leaves a trace. And this has become known as Locard's exchange principle. It is the foundation behind all digital forensics, that no one can do anything without leaving behind a hint of some kind. So these principles and methods that have been given to us via Mr. Locard have grown into the full-featured science that today we call digital forensics. And the bottom line is, you can do all kinds of collection and studying, but whatever is done must be trustworthy. Witnesses, judges, other people in the process must have faith in your process. They must trust the data and the evidence that you are providing. And this comes to the next topic, evidence validation. So this process of establishing your evidence's trustworthiness originates in some rules that have been written into the law, and there is one called the best evidence rule, which states to prove that the content of a recording or a photograph or a document is true, then we must see the original. This goes back to physical media. So a document would have been in paper, or an original recording on a vinyl disc. But as we've moved more and more into the digital arena, the federal rules of evidence have allowed duplicate data to be used as evidence, and you can see the exact wording is when the duplicate is produced by the same impression as the original. And you might say, well, what does that mean? So it was stamped out of the same form as the original. So in the case of a digital replica, as we are going to produce in one of the labs in our class, we do a bit-by-bit copy of the original data, and those copies, those replicas, may be admitted in a court of law as long as we provide some type of proof that that replica is an exact copy of the original. And one of the ways that you can provide that proof is through a hash signature. And there are various hashing. There's the SHA MD5 and others that show that the calculated hash signature of an original matched that of the copy, which shows that the two are digitally identical. There is something, of course, a legal term of best evidence, and these copies are not falling into that category of best evidence, but can be used as corroborating evidence. So typically, any kind of digital evidence we provide must be in addition to first-hand evidence, witness testimony, or visual camera recording, or some other first-hand evidence. So when we talk about admissibility in court, there are three key attributes which are going to test whether any particular item is indeed admissible. It must be relevant, reliable, and material in nature. So you should understand what each of those means. Of course, when something is relevant to a case, then it must not be going off on some kind of, tangent road to sort of go down some, side avenue to try to explain how, crooked our defendant is. You can imagine various TV scenarios in the courtroom where they admonish the either the district attorney or the prosecuting attorney, let's stick to the case. That is often due to the fact that we are going outside of relevancy. Reliable, I think, is pretty straightforward. This evidence has to have our trust. We have to believe that it hasn't been fabricated in some way. We have to believe that it's been handled with care and by people who respect the law. And then lastly, the evidence must be able to prove a fact in our case that might otherwise be disputed, and this means that it is material in nature. You may want to reference this URL at readsmith.com, which has a interesting Adobe Acrobat file which gives a lot of good data on electronic evidence and its admission. So we've collected our information, we've handled it with the utmost of care, it's been stored properly along the chain of custody, but all of this evidence must be carefully cataloged, cross-referenced, and finally analyzed. And when evidence, like digital evidence, is collected from log data or off of servers, we can start to be dipping into a highly technical realm. So to understand this data and its meaning, we may need to call on the assistance of a very specialized professional. This would be the expert witness. Expert witnesses are those individuals who are highly trained in a specific discipline and can offer great consultative services during not only the evidence analysis, but also the, we'll say, the explaining phase during a court proceeding. We'll talk a little bit about that in a minute. But a professionally prepared final report of some kind, probably a written report, but some may also be of an oral nature, needs to summarize the case, walk us through the timeline so we know what things were precursors to what other things, and explain the methods that were used so that we can have trust in the process and lead the reader or listener to a conclusion. So this expert witness is a person, again, highly trained, by virtue probably of education, probably has a PhD in some forensic discipline, or perhaps they'd be a highly trained system security individual, probably have many certifications, lots of experience, and would be accepted within the courtroom as an expert. Okay. That said, the judge would consider this witness's specialized opinion about evidence as long as that expert opinion walks that narrow line of maintaining within the realm of that person's expertise. And in the legal arena, this type of testimony is referred to as the expert opinion. So let's juxtapose our normal lay witness against this special role of the expert witness. So when we think about witness testimony in general, I think most of us think in terms of what is called the material fact witness or lay witness. And these people are those that have some kind of first-hand knowledge of the matter at hand. They saw something. They heard a particular sound. They smelled something in the air in case of a fire that was part of the crime. As an example, within the realm of information technology, perhaps an IT professional observed child pornography on the computer screen of someone in the, next corridor, and then would be able to testify to this as a material witness. On the other hand, we have this individual we call the expert witness, and they are not personally involved in the case at hand at all. Rather, this person has very specific and specialized knowledge about the subject matter at hand. So, we may, in this same child pornography case, be able to explain that malicious software could infect our system and could cause illegal pornographic information or images to be downloaded to a person's computer without that person's involvement or even knowledge. So this expert's opinion could be used to absolve our defendant. When choosing an expert witness, or when someone hangs out their shingle to want to be available as an expert witness, there are some qualities that would be very important. Again, we've talked about an advanced degree in a specialized field, notoriety in the industry. Perhaps they have been a keynote speaker on a very specific topic at a national or international symposium. They perhaps led some very specific research and have been published in a variety of peer-reviewed journals. And it is clear that we just want a very smart man or woman to be the expert witness. But there are also some other qualities that would be very important. So imagine this individual up on the stand and in the court of law, their hair is spiked all over the place, and doesn't look like they washed it in a week. It might not, give the jury or anyone else involved, a lot of faith in this individual. So we also look for some personal qualities, a neat professional appearance, something that evokes trust in the person. Of course, we want this person to have a very clean background check. We don't want anyone digging into their history and finding something that would bring out a lack of trust in this individual. Of course, they should have no conflicts of interest that would bend their opinion in one direction or another. And of great value would be a skill in explaining a very complicated topic to a lay audience. So I hope that this discussion was interesting and helpful to you. I know it will help you as you do some of the assignments coming forward and complete the material in the unit.